And hello once again. Welcome to Employment Hour in 30. John Scholes, Lior Samfiru. To reach out anytime, 1-855-821-5900. Help at employmentlawyer.ca. Lots of things coming up on the show today, including the 5 things. Yeah, I got it right. 5 things an employment lawyer can do that you probably can't. I know we're not talking squatting 500 pounds. We're talking things within the legal realm.
I can do that too, but
no, you can't. No. In fact, I'd like to see him try on the next show. We just might do that, guys. Lots of stuff to get through today. First a week that was, brother. What do you got happening?
Squatting 500 pounds. Wow.
Oh, why not?
Okay. Well, why not? We'll try it. But it has been a busy time at the office. A lot of people that watch this show call me with questions. It makes them realize that there's things that they could do about the workplace problems that they're facing, which is terrific. It's exactly why we're here. So keep those coming. Keep those going. Happy to talk to all of you and any of you with respect to those workplace issues, workplace problems, to give you some guidance, some comfort, hopefully, that there are solutions. And of course, if I need to, I'll get involved to help you solve those problems. There's always workplace solutions to those problems. And that's what we do here on this show. So stay tuned. We'll educate you throughout the show about important things. And the week that was, John, let me tell you about a situation that came across my desk. I got a call from a very frustrated truck driver. He had been working for the same company for about 27 years, long time with the same company. And you know, it sometimes happens when you're a truck driver. I've seen a number of truck drivers in this situation. He started developing chronic back pain. Yep. And one of the things that's always bad for people with chronic back pain is sitting for extended periods of time. Well, he was a long-haul driver. And because of that, he'd spend 12, 14, 16-hour days sometimes driving. Terrible. And doing it a number of days a week. It really was bad on his back. So he spoke to his doctor. His doctor said, can't do that anymore. Those days are behind you. You have to do shorter routes now. He could still drive 4, 5, 6 hours at a time, no problem, but not those really long-haul trips. Spoke to his employer, spoke to the company he worked for, and said, I need you to help me out here. I want to do the short-haul trips. They had plenty of those, by the way. They looked at him like he was crazy, and they said, well, what are you talking about? You're the long-haul driver guy. Yeah. We don't have other work for you. We're not going to give you other work, so I guess if you can't work, you're quitting. He said, well, I'm not quitting. What about severance? They looked at him like he was even crazier. I said, well, you're an independent contractor. You're an owner-operator, 27 years. Those severance for you, of course. That's when he called me. Luckily, he actually had watched the show a couple of years prior, and he called me. And he said, well, Lior, what are my rights here? So let's start with the back issue. Mm-hmm. He has to be accommodated. This is a very common situation. If you have a medical condition that requires assistance from your employer has to provide that assistance. Whether it's modified duties, modified hours, whether it's some help to do your job, the ability to work from home. And in this case, it was giving him the shorter route so he doesn't have to sit for 15 hours a day. Right. Easy to do. They could have done it. They chose not to. If a company can do it, they have to, as long as it's legitimate and as long as you have something from a doctor. So right there, that was a human rights violation. They breached the human rights code by not accommodating him. It's illegal. They had to. Now, beyond that, let's go to the second issue. He's not an independent contractor, John, and I see this all the time with truckers. You may be watching us right now. You may be a truck driver, and you think, wait a second, are you saying I may not be an independent contractor? Yeah, that's exactly what I'm saying. You're probably not. Happens oftentimes with many industries. Certainly happens with truck drivers. Even though you may own the truck or the plates on the truck, you are likely considered to be an employee in the eyes of the law, which means you have very significant entitlements, including the right to get severance if you are let go. So, going back to this particular case, human rights violation. They didn't accommodate him when they should have. Number 2, they terminated his employment, didn't pay him severance, so a wrongful dismissal. After 27 years, he's going to be owed 2 years' pay plus human rights damages, significant entitlements. So a very important reminder there to all of us, not just to truck drivers. If you have a medical condition that needs accommodation, your employer has to accommodate. Whatever that is, as long as the doctor backs that up, the company has to find a way to make that happen. And number 2, you're probably not an independent contractor. If you lost your job, doesn't matter what you signed, doesn't matter how you've been paying your taxes. I've said this before, I'll say it again. The law decides if you're an employer or contractor. In this case, he's an employee. He's owed severance.
And I guess you could slide under the banner of number 3 in that one. If someone tells you, oh, I guess you're resigning, that's not a resignation.
No.
You have to make the call.
You're the only person that can decide if you resign. If someone tells you you have to resign, that's not a resignation. The moment you have to do it, it becomes a termination. And if it's a termination, you're owed severance. And good advice, if someone tells you to resign, unless you want to resign because you don't want to work there anymore anyway, do not resign. Say thanks, but no thanks. Let them terminate you. Let them pay you severance. Don't make it easier on the company to avoid paying you what you're owed.
EmploymentHourTV.ca, the place to go to find our radio show, which we've been doing for years and years. We get a lot of phone calls on the show. Of course, we play the good ones. Well, not the good ones. We play the interesting ones back here. And we talk about them. First call for the day right now.
Company hired me for independent contractor for 5 years, and then they make me a full-time employee. Now the company is being sold. They are only giving me a severance for only the last 6 years. Am I entitled for the whole 11 years?
How much have they offered you?
Only 4 months.
Right.
They're a little off.
I remember this call from our radio show. So he worked supposedly as an independent contractor 5 years, and then he magically became an employee after that. Well, guess what? You don't magically change unless you were in business for yourself and all of a sudden you became, no, nonsense. He is an employee. He was an employee all along. And I've seen this happen many times where you start off as an independent contractor, then somehow magically become an employee. The law would say that you were likely an employee the whole time.
Yeah.
And that's the same thing with this particular person. So now that they let him go, he's not a 6-year employee, he's an 11-year employee. So he's owed severance based on an 11-year length of service. Very important. You may have been in that situation. Maybe you worked for a number of years as a contractor. Those count. Those counts towards your seniority if you are let go at some point, and your severance should be calculated properly. So how do we know what this person is owed? Remember, he's an 11-year employee. Right. Well, let's just do it the easy way. Let's go to severancepaycalculator.com. Again, severancepaycalculator.com to find out how much this person is owed. You can see on the screen. So he's been there for 11 years. He's a professional. I picked an age. Let's assume he's 48 years old, and he was given 4 months' pay. As you see on the screen, Severance Calculator correctly assesses him as being owed north of 12 months, 12 to 14 months' pay. I don't know how much this person earns, but it's going to be a big difference. So 12 to 14 months, you can see on the screen. The interesting thing, John, is even if he was only a 6-year employee, that 4 months would not have been enough. Yeah. Still a wrongful dismissal. Yeah. That's why it's so important to get advice. That's why it's so important to go to severancepaycalculator.com.
And you can call anytime, 1-855-821-5900. There's also terminationquestions.com. You ask your questions there. They get answered by Lior, a member of his crew. Rather quickly, there's a good chance your question has already been asked and answered, so make sure you check it out sometime, terminationquestions.com. First one for the day says, I was lured away from my job of 18 years for a sales position with a new employer. After 3 months of work, the business has slowed down, and my new employer is thinking of letting me go. Thinking about it, what are my options?
Can you imagine what a scary situation that would be? You have a secure job, you've been there for 18 years, it's a long time, and then another company comes in and makes these big promises, grandiose promises to get you to leave. You leave, and now you may find yourself out of a job.
Less than a month. Less than
a month when you weren't looking to leave to begin with. Yeah. Scary situation. So the law deals with that. The law recognizes that that's unfair. So what happens in a situation where you've been recruited away and then are let go? Well, the law says you should get credit for service with the other company, even though it's a separate company, even though it has nothing to do with the actual company that let you go. They should have to pay you severance based on those total years. Now, that only works if you have long service with the previous company. If you've been recruited away, you weren't
induced from the company.
You've been induced. You weren't looking to leave, and you've only worked for a relatively short period of time with the new company. If you can meet those criteria, you get an enhanced severance that recognizes the service you had with the previous company. Now, for this particular person, in terms of his options, number one is I want to make sure, ideally, that he did not sign an employment agreement that limits his entitlements. Right. So important. If you've recruited, if you're induced to leave a secure job, do not sign an agreement that limits your entitlements. You will regret it later. Now, if the company is going to let him go, there's nothing that we can do to stop that. Remember, they're allowed to let him go. It becomes an issue of severance. So if they let you go, call me. Let's talk about that. You could be owed severance based on 18 years.
Yeah, huge.
Even though you've only worked for the company for a few months. Very important. It could be potentially hundreds of thousands of dollars that you're owed.
5 things an employment lawyer can do. We talked about it off the top. Want to get into the 5 here and go through them. First one, I mean, it's an obvious one. Secure a fair severance package, right?
That's right. And people do ask me, you're an employment lawyer, Lior, what is it that you do? How can you help me? So we want to talk about a few things, just a few things that as an employment lawyer, myself, my colleagues, we do. And probably one of the most common things that we do is we help secure proper severance for those that are let go. And the reason we need to get involved is because over 90% of people, over 90% of the time when someone is let go, they're offered pennies on the dollar. We've talked already on this show, on every show. We've given you dozens of examples. We'll continue doing that because I see those cases every day. There's no lack of them. So my job, my team's job, is to make sure you get the severance that you're owed. And it's usually not a situation where you've been offered 6 weeks and it should have been 8 weeks. It's usually a situation you've been offered 6 weeks and it should be 8 months. Yeah. So that's why it's so important to contact us, to allow us to get you that severance. And here's the interesting thing is, it's not difficult to improve severance if you work with someone that knows what they're doing. It could be very quick, it could be very painless, and it's not a process that's going to drag on. Yeah, a lot of what we do, John, is we secure that proper severance.
It's also the fact that it's a matter of clout. I mean, someone who's watched this show since we started, or 7 years of radio show, goes, no, I know what to do. I'm going to go in and talk to them,
right.
Say, I was told this and this. They're going to go, yeah, and? But you get a lawyer involved. Now they have no choice but to step up.
It gives you credibility.
Yep.
And number two is if you're dealing with the company, remember, the company itself may not understand what their obligations are. When I get involved, the company's going to speak with their lawyer who's going to tell them, yeah, you owe them more. Right? So if you're dealing with the company directly, you're not going to be usually able to achieve the result that you want. It may sound self-serving, but I've spoken with hundreds of people that have said, Lior, I've tried. I couldn't improve it on my own. Do you think you can help me? And we invariably do that very quickly.
You ever try to fill your own teeth? No, you go to a dentist.
No,
okay.
Exactly. Let us do our job.
Let the pros do it, right?
Exactly.
5 things an employment lawyer can do. Number 2, evaluate your employment contract. This is arguably the most important document in your life, next to your marriage contract.
It is. You signed the marriage contract? Yeah, no. But it is an important document because we spend so much of our time at work. Work is such an important part of our job, and the employment agreement, the employment contract, is the agreement that governs what happens at work. So a lot of people pay attention to only a few things when they sign an agreement. They look at what the salary is, how much vacation is, maybe if there's a bonus. But there's so many more important things that could cost you tens of thousands of dollars. Things that allow the company to let you go without severance. Things that allow the company to change your job, to reduce your pay, to lay you off temporarily. Many other things as well. You need to understand what those are. A lot of what we do is evaluate that employment agreement and help negotiate it. Number one, help you identify the problems and tell you how to get rid of it, how to modify it. Do not sign an employment agreement. Certainly if it's a more senior role, do not sign one without getting advice. If you don't care now, I promise you, you will care later.
And especially if it's a thick one, a bulky one, because, counter to what you normally think, you don't want that much detail. You want a one-pager. So if it's thick, it's even scarier.
So let me modify what I just said. If you're getting a half a page, I'll give you permission not to have it reviewed, okay? Yeah. If you're getting anything more than that, certainly if you're getting a 7, 8, 20-page document, you absolutely have to have it reviewed because in that 20-page agreement, there are going to be at least a dozen things that are going to be problematic for you. Yeah, as an employee, as counterintuitive as it sounds, as you just said, John, you are better off signing a short document, an email, much better than a long agreement.
Help@employmentlawyer.ca is the email address to reach out. 5 things an employment lawyer can do that you probably can't, and that is make sure you just don't give up your legal rights.
Yes, it's a broad term, but a lot of times people come to us in situations where something has happened, they want to know how to respond, and our job is to make sure that they preserve their rights. Maybe your job has changed, your company has reduced your compensation, they changed your job. If you don't get some advice, you'll find out that you've accepted those changes. Yeah. And you're like, wait a second, I didn't want to do that, but you did. So a lot of what we do is we preserve those rights. We make sure you don't give up your rights and you are in a position to enforce them. So if something happens in the workplace, your employer did something, said something, you probably have rights, but you also probably only have a small window to pursue those rights, to enforce those rights, to maintain them. So if something happens in the workplace, you need to give us a call so we can at least decide what the best course of action is so you don't give up your rights.
The next one on our list, give your employer, quote unquote, a kick in the pants when needed. I believe that's a legal term.
That's a legal term. You didn't go to law school, I did, so I know more about that. No, but I like to call it a kick in the pants. Sometimes your employer is doing something it's not supposed to, but you don't need to take legal action. You don't need to start claims. You don't even need to threaten your employer. Sometimes just us sending them a bit of a gentle reminder, hey, you can't do that or you should be doing this, is all that a company needs. Right. Maybe your company doesn't pay you overtime properly. Maybe they're not doing vacation pay calculations properly. A little nudge from us, a little letter from us can correct things, and we'll take the position, well, you know what, I'm sure you meant to do it the right way, employer, but you didn't. Here's the right way. That kick in the pants sometimes is all your employer needs. So it's kind of the path of least resistance. And a lot of what we do is we provide these gentle kicks, gentle nudges to employers. And if you think your employer may be doing something wrong, we can often help fix that problem, correct that course of action, and make sure that your rights are preserved.
Our list of the 5 things an employment lawyer can do, number 5 on the list, our last one for this one, is handle negotiations with your employer.
Yeah, oftentimes when legal rights have to be enforced, these matters resolve. They don't go to court. We negotiate resolutions.
Yeah.
And you need to have an experienced negotiator, someone that knows how to get the best deal, the best value. That's what we do. We're negotiators. We're professional negotiators is what a good employment lawyer is. And you need to have that on your side. So a lot of what we do is we line up against an employer and an employer's lawyer to help negotiate the best terms possible. It's not complicated. You just need to know what you're doing.
A wonderful tool built for you anytime to check out and can save you and make you money as well, really, is the severance pay calculator. We'll talk about that after a short break. To reach out, 1-855-821-5900. Employment Hour in 30. Lots more on the way. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Hour in 30. Time to cover the severance pay calculator. Have you used it or at least looked at it, tried it just for fun? Severancepaycalculator.com, right?
Wow, yeah, so many people have used it. Such great feedback I've received over the past 6 years or so of having it. So severancepaycalculator.com, the very first place you go to if you lost your job. Why? Number 1, it's easy to use. Number 2, it's anonymous. It's free. But number 3, and probably most important, it's accurate. It tells you what you're owed, what your legal entitlements are if you lost your job. And I know some people may think, well, why do I need that? I know exactly what a week per year of service is. I can do that math in my head. I don't need a calculator for that. Well, it's not a week per year of service. It's not 2 weeks per year of service. It's not 3 or 4. For most people, it could be much more than that. It's based on your age, your position, and the length of your employment. So when you go to severancepaycalculator.com, you're going to be asked what's the length of your employment, how old you are, what kind of job. You just pick it from a drop-down menu, and you are done. It's going to tell you the number of months' pay that you're owed. You can even calculate that in dollars if you wanted to. You don't have to put in your name, the company's name. You can take that information and walk away, or if you want, and only if you want, there's a green button there that you can press to contact me so that I can help you enforce those rights. And that's why it's so important to use. If you have that severance letter in hand, you go to severancepaycalculator.com. Or maybe you're like many people that contact me. You haven't been let go, but you're worried about being let go. Something's happened. Maybe there's a restructuring.
You're sensing it.
You're sensing it, and usually you do. Usually you can. Well, you want to be prepared, or maybe you're curious. Go right now, check it out. Grab your smartphone, grab your tablet, go to severancepaycalculator.com, find out how much you're owed. You'll be surprised.
We'll run an example through the calculator. 53-year-old Hamid was let go from a technical role after 6 years. He was given a check for 2 weeks' pay. That's it. Hamid's employer said he wasn't entitled to anything else as per his employment contract, but he doesn't recall ever signing one, and his employer now refuses to provide him with a copy. What does Hamid do?
So we talked before on the show about employment agreements and why they're so important. And one of the things an employer can try to do in an employment agreement is limit the amount of future severance that you will get. They can do that. And that could potentially, if you have something like that, it could cost you a lot of money. Now, the good news is, number 1, a lot of employers don't try to do that. But even those that do try, they don't do a very good job of it. So even though you may have signed an agreement that limits or tries to limit your entitlements, it may not actually be effective or enforceable. So even if you sign an agreement, even if you believe that that agreement limits what you're owed, you have to give us a call. 75–80% of the time, that may not be enforceable. Something you can get around and still get your full entitlements. Now, with respect to Hamid, yeah, if he doesn't believe he signed an employment agreement, company has to show him. Company has to provide it. And chances are that even if he did, it probably doesn't limit his entitlements. Therefore, he has full termination entitlements. So we talked about severancepaycalculator.com. Let's plug Hamid's information into the calculator and see how much he's owed. And spoiler alert, it's not 2 weeks' pay. So technical specialist, 6 years of employment, 53 years of age, was given 2 weeks' pay. That's a joke. He's owed right around 8 months' pay, as you can see on the screen. 8 months. If he was making about $70,000 a year, that's an extra $45,000. An extra $40,000, John, that he would be owed in that situation. That's why it works. That's how easy it is. So check it out yourself.
You know, it's funny you mentioned the employment contract, and you said, you know, even if you have one, it may not be legally binding, because a lot of employers who aren't sophisticated might just download a template off of Google, and you're like, no, you can poke holes through that all day.
Oh my God, yeah, or they use some sort of a US template, or they don't have it properly drafted, they download it from Google or from somewhere else. Chances are that's not with the paper it's written on. So even if you sign an agreement, even if you think it's proper, yeah, give us a call. We can tell you in 60 seconds whether it's enforceable or not.
EmploymentHourTV.ca is the website. That is where you will find a link to a radio show near you. Call number 2 from the radio show coming up right now.
My employer right now is looking to reduce my commission structure by more than half of what it is right now. I'm just curious if this is something they can do or if they have to compensate me in another way to make up for that. They were looking to offer minimal bonuses that don't seem to even come close to what the potential is on the commission structure.
50%.
Oh my God. I mean, our regular viewers are going to know exactly what I'm going to say. They've probably answered this question already themselves just hearing that call. No, of course the employer cannot do that. Your employer cannot change your compensation this way. Now, this particular situation, 50%. Holy cow. Even if it was a lot less, even if it was 10%, no, the company would not be able to do that. If a company changes your compensation in a significant way, you can treat that as a constructive dismissal. Most of our viewers have heard that term, constructive dismissal. It happens when the terms of your employment have been changed by your employer and you decide not to accept that. Yep. You decide to treat that as a termination and leave with your severance. You can do that, and in this particular case, the caller that we heard the voicemail from there, no, he absolutely can leave with his severance. 50% is massive. Doesn't matter if the company's trying to make it up somehow, some other way. That's a change to the terms of employment. I can't think of anything more egregious than reducing someone's compensation by half. Same with you. Your compensation maybe has changed. That's a constructive dismissal. But maybe other things have changed. Maybe your job has been relocated. Your duties have been taken away. Maybe you've been demoted. If you're facing a change like that, you need to get some advice because you only have a very small window to pursue a constructive dismissal.
I mean, obviously, this guy's not going to go for it as 50%. But say he's like, yeah, you know, maybe they will make it up somehow. Maybe in the end, I'll come out even. What are the pitfalls if he goes, okay, let's try it?
Well, number one, if he believes that he's going to get me made whole, he's going to have another thing coming. It's not going to happen. But also, if he accepts that change, right, he gives the company the right to do it again. And this time it's 50%. What happens next month when it's another 50%? At that point, he can't do anything about it because he let it happen the first time. And of course, if he does take the 50% pay cut and then they let him go, then he still gets severance, but it's calculated based on the lower income. Yep. Don't let that happen to you. If your job changes, if your compensation changes, you have to do something about it.
Can a nervous breakdown trigger a termination at work? We'll find out the answer to that after a short break. 1-855-821-5900, the number to reach out anytime. Employment Hour 30. Stick around. More coming up.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team 1-855-821-5900 or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30. John Scholes, Lior Samfiru. A few minutes left here to go. Anytime you want to reach out, you can do so on the radio show. Employmenthourtv.ca is where you find those shows. Call number 3 for the day, my friend, is coming up right now.
Actually, I just got let go today from my employment. 20 years. It was a sales job, and I'm 60. And employee benefits, they gave me 2.5, 3 months of continuation.
A little weak.
Yeah, I mean, try to challenge me a bit, man. Come on, it's not even close. Obviously, he is owed much more than that. You don't need to be an employment lawyer. By now, our regular viewers know that that's nonsense because they know they've listened to the show. He is owed much more. Come on, after 20 years of employment, 60 years old, sales. This is a call we got on the radio. So rather than me tell you how ridiculous this is, let me show you how ridiculous this is. Let's go to severancepaycalculator.com right now. You'll see that on the screen. 20 years of service, salesperson, 60 years old. Generously was offered 3 months notice of termination. It should have been 18 months, as you see. Severancepaycalculator.com shows us 18 months. There's a slight difference of 15 months pay that he's owed there. It really is silly to me that employers still think they can get away with that, but they do. And in most cases, they actually get away with it because people don't know any better. You're watching the show right now. You know better. You're one of the few, fortunately, that has that information. You're armed with the knowledge. So spread that knowledge. Tell other people about it. Make sure that no one else is taken for a ride. Tell them to go to severancepaycalculator.com. For this one voicemail that we just heard, it was worth an extra 15 months pay, and there's nothing unique about that. Very important.
Another question from terminationquestions.com. We'll get to that as we wind up here. It says, I had a near mental breakdown while at work last week. My boss gave me 2 choices on the spot: take a demotion and pay cut or lose my job. I chose the second option. My employer is aware of my mental health challenges, but instead of trying to help me, they pushed me out the door without severance.
Yeah, well, it's exactly the word help using that in that bottom of that question is important because your employer does have to help you. They have to provide accommodation. They have to allow you to do your job if you have limitations. And if they realize that you're not in the right mental health to make decisions, they have to encourage you to take time off to see a doctor so that you can get that help. They can't take advantage. An employer cannot take advantage of someone that's clearly vulnerable. Mental health issues are serious issues. The fact that you can't see them on an X-ray doesn't mean that they're not real. Doesn't mean that they're not debilitating. And if you have a mental health issues, your employer cannot take advantage of that. They can't reduce your pay, punish you in any way, make you resign, consider you to be terminated. None of that can happen. They have to accommodate you. They have to provide you some help. They have to encourage you to see a doctor if that's the right case. So in this particular situation, this person wasn't accommodated. He was taken advantage of. So that's a human rights violation. Right. And they were terminated. The fact that they said you should resign, that's nonsense. That's not a resignation. This person didn't want to leave their job. They didn't want to be out of work. They were terminated. So they're owed severance. So mental health issues I see come up all the time. When I started practicing law all these years ago, people didn't talk as much about mental health issues. People, thankfully, now are not afraid to talk about them, whether it's anxiety, depression, something else. Right. If you have mental health issues, those are real. You still are entitled to accommodation. You're entitled to your job while you're off getting better, getting healthy. Make sure you have a doctor that corroborates what you have. And if your employer gives you a hard time, like this person, you call me, you email me, and I will help you.
And this, like any physical injury, you're off when your doctor says you're off, and you're off until your doctor says you can go back, right?
The doctor, as I like to say, is judge and jury when it comes to your ability to work. When it comes to your requirement to take time off work, your employer can't say they don't agree. They can't say they don't believe you. If your doctor says you cannot work, whether it's mental health or a physical injury, you have a right to be off work. You have a right to take as long as you need to, and your employer can't do anything about it. If they terminate you, that's a human rights violation. It's a serious issue. It's a big deal. If that happens, you call me, you email me. I'll make sure you get what you're owed.
We are done for the day. You want to wrap up and contact, no problem, 1-855-821-5900, help@employmentlawyer.ca. And again, you want to source those radio shows out as employmentourtv.ca as well. We'll see you next time. Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.